Hey folks, welcome back. We're talking about parallel parenting today, boundaries, structure, and legal clarity. This is a question that comes up so often in my private coaching sessions. And with me today is a very dear friend and colleague, Randi Karmel. Randi, welcome.
Thank you. Thank you for having me.
I'm excited about today's conversation. And as you folks know, when co-parenting is a constant source of conflict, it's time to consider a different approach, one that minimizes contact, reduces courtroom battles, and places firm guardrails around your interactions to keep you safe. Parallel parenting is designed, as you know, for high conflict dynamics, offering clarity, boundaries, and the ability to parent more effectively. And yet the question is, what does that mean? And how is parallel parenting different from co-parenting? And most important, if you're still in the legal process and the negotiating, how do you build that parallel parenting structure into your settlement agreement? And that's the conversation I'm going to have with Randi today. Just a little bit about my guest before we dive in. She's a powerhouse in the world of family law. She brings a rare, well-rounded perspective, so heart-centered. Not only does she litigate and mediate high conflict custody matters, she also serves as a parent coordinator and has represented children as a guardian ad litem directly in complex cases. And so you can read more about Randi in the show notes. But with no further ado, we're going to dive right in. Hey, Randi.
Hi, and thank you again for having me and for that intro.
Yeah, this is just a topic that I find has so much nuance and so much complexity. And so let's just dive right in with your definition of parallel parenting.
So, parallel parenting is actually something that I consider new. I've seen it much more in recent times than in the past. It's really designed to minimize interactions between the parents and minimize communications between the parents while maintaining independent parenting styles. That's the key. Is it is so both parents can parent the way they want to on their time without necessarily getting consent for certain things that they do that may expand more than just day-to-day decisions. And that's where I think it becomes very complex and why you need a very detailed parenting plan, because there are situations where a parent may think, and if I could give an example, being on a jet ski, is that a day-to-day decision if that's you're spending part of the summer with your child? Or is that considered that's a dangerous sport and that should have been something we speak about? Is that something that would go into a parenting plan? So day-to-day decisions, I think the parallel parenting expands that definition, and it puts a parent either at ease that I could do what I want, or maybe not so at ease because you don't have necessarily the, for lack of a better word, control. Bedtime hours,
Mm.
hygiene. It's very difficult for a child to have a 9 o'clock, 9 p.m. bedtime in one house and a 7:30 in another. Those are some of the issues of parallel parenting, but they can all be worked out in a very detailed stipulation of settlement.
Yeah, and I think the common message that we hear, as it should be, is about co-parenting. And so I have so many clients and listeners who they haven't had that ease of communication, flexibility, compromise, and yet they're stepping into co-parenting, expecting that if I give my child consequences, you'll hold them at your house. If I have an electronics rule, you'll hold it at your house. And that creates its own conflict because it's like you have conflict with this person to begin with everything. And then there's the fear, and I want to talk about this too, the fear that if we parallel parent, we're messing these kids up because they have two different bedtimes, because they have two different roles, because they have such diverse situations in each house. And so before we dive into the details of it, How would you respond to those concerns?
I think they're all valid, and they're my concerns as well. I think that with parallel parenting, a child can feel that if I go to one parent's house, I'm allowed to do X and I'm not in the other parent's house. I do think that there are some children who are very mature and understand that each home is different and that that's okay. But there are times when it causes more conflict. And that's why I always go back to whether it's co parenting or parallel parenting, the more that you have in a stipulation, the better. But I do think that there is anxiety sometimes with parallel parenting with a parent, let alone the child. Child comes back, or there's an exchange day, and all of a sudden you find out the child was riding a horse and you didn't necessarily know that, and the child might have fallen, had protective gear, but still, this is something that you might not have actually said at this particular child's age or maturity, and it was not discussed. And can you then discuss it? That's up to your communication provision. But I can tell you that my stipulations of settlement, and I think a lot of lawyers, we have added a lot to our definition of what a major decision is.
Oh,
Many
that's
years ago, I
interesting.
did not have technology in there. Now we have technology. And what
So,
is technology? Use of a phone. Does it have a tracking device on it? Who can call it? It's not just one word anymore. It now has expanded.
so you sit down with a client and you know the landscape well enough to know that they need a parallel parenting settlement agreement, that those guardrails are going to serve everybody. Where do you begin?
You begin with, and that's a great question, actually. You begin with finding out what the real issues are in the family, if you can. Okay. So, just some examples. Is it somebody who's narcissistic? Okay. Is it somebody who, in every communication, says something nasty? Cannot just say, this is where we are. This is the itinerary. It's because you want to know, because you're very nosy, and because you want to bother my family. This is where we're going to be on such and such date. You have that could be a consideration. Something that most people, I think, overlook, but I have seen this as a form of abuse. How many communications a day? I have seen this as a form of abuse. Response times, that's an issue. I'd like to know if about the child or the children. I'd like to know if there's alienation going on, whether it's, as we say, wittingly or unwittingly, is a parent alienating. So then once I know what the issues are, I look at a stipulation of settlement and I think to myself, that how comprehensive does it have to be? And that's my first step, is thinking, how detailed do you need to actually put in things like, if there's no school and camp, who will be picking up the child? Is it
Yeah.
the person who drops off won't drop off? Or is it, well, that was going to be, you ended at 8 a.m. Now it's my time. So these are things that sometimes clients are like, we don't need that. I always think you do, and then maybe not follow it just in case. But, or do we really need to have that? Do we really need to have a parenting plan where it says the parent who wants to make a decision sends the other an email that says major decision and what it is, and then the other has a time period by which to respond? Because if I hear that we don't communicate, and sometimes my emails are left unanswered for weeks, now we need the provisions of time frame. So I try to find out what the issues are and then frame a stipulation of settlement based on that particular family.
So if we start with the calendar before we get into the decision making, if we start with the calendar, some of the things that I have seen is with vacations. So let's say dad gets to decide on the odd years first and mom gets to decide on the even year. And let's say it's an even year and mom's the one who's higher conflict. If there's not a date as to when she has to decide, and I've seen this with a number of clients, they just don't decide, and they kind of like put the other person between a rock and a hard place. What are some of the examples that you have of challenges with the calendar itself and scheduling that custody time?
First of all, just to go back to your question, usually if the person misses the deadline, the other has first say.
There's a
So
deadline. So
yeah,
that was the part I
there's
wanted you to say.
definitely a deadline. And again, that's somewhat also what I was talking about with major decisions and how to handle that. And just to be a little bit more detailed, some people just say, I'll send an email. Fine. Other people, we have to put in our agreements that the subject line has to say major decision. Otherwise, they may not open it. So again, the details depends on the family. Okay. Some people would say, I don't need that. Give me a break. I'm not a child. Other people say, that's brilliant. That way it's all listed under a certain decision, and that's that. So, yes, I do think that with schedules, vacations, holidays, any recess periods, pick up, drop off, all of that has to be definitely, in agreement. And there has to be, I don't want to say consequences, but there has to be a resolution if something doesn't happen in a certain time frame. There
So
has to
I gave the example of the vacation time, and you're saying, okay, so what we would do is we would give you a deadline. You have to make a decision for the summer by whatever, May 1st. And if you don't, then I'm hearing you say it kind of pings to the other parent. So that to me sounds like such a great way of controlling what happens to the degree that you can. Can you give us one or two other examples on the calendar where you're putting in some guardrails and some resolution? I like resolution over consequence. Thank you for
yes,
sharing
and
that.
and that's the key nowadays, is the resolution to keep people out of court. That is the key. So another example, as I said, it's if there's no school or camp. Okay, when does the pickup or the exchange happen? If all the pickup and drop off was at school, let's say, and all of a sudden there's some administrative day that people didn't realize, or it's a snow day, something you
Perfect
don't
example.
anticipate. So let's do a snow day. So where is the child at that 8 a.m.? Does the child exchange to the other parent, or does that parent's time start again at pick up from school? This became an issue during the pandemic because there was no school. People who had old agreements didn't have things like that. So that provisions like that. So yes, that became an issue. So that's one. And a resolution is to deal with that. When is the actual time for the other parent, the one who was supposed to begin? When is that? So that's an example. Also, an example is a child's birthday. Some people want to share in that birthday. So when there were old stipulations that said, and both parents will spend time with the child on his or her birthday, well, that's marvelous. Tell me what happens on a Saturday, and tell me if a parent makes a party, and when does the other parent get time. So now what I do is I set times. So I'll say in odd years, let's say parent X will have, I'm making up time, 9 to 12 or 9 to 1. And then the other parent who has the child normally will have the rest of the day and then the overnight, and then switch it, because there were fights and lawyers can't do much on a Saturday or Sunday. If it's the child's birthday on a weekday, now I have pick up and drop off times. One parent will pick up from school, will spend 2 or 3 hours, and then the other parent. So those are ways to handle it if the parents can't otherwise agree. It's always good to have a backup plan if the parties cannot agree at that time.
Let's talk a little bit about what the term right to first refusal means, when it's applied, when it's inappropriate to apply it, and how you have resolution when the other person's like, yeah, I disagree.
So this is one of those areas that hold up settlements. And it's one of the final concessions and issues that people decide on. So let me tell you why. A parent can say, I am available every day after school, but the other parent isn't and needs childcare from 2:30 to 6. I want to pick up the child every day after school, and then I'll drop the child on the other parent's time. the parent who works outside of the home and needs that child care, or the child's in after school, says, wait a minute, on my time, I do what I want. On your time, you do what you want. This is confusing. A child's not going to go to your house and then to my house, and basically stay out of my days. Leave us alone. That's what's happening. So that's a perfect example of a right of first refusal that somebody wants for a couple hours rather than a child care provider. We've had, and again, the resolution to that usually is that the parents don't have that arrangement where somebody is picking the child up. It's confusing for a child and then going to the other parent. So I think in almost every one of the cases that I've seen, it sort of ends with, you'll do what you want on your time. And if you need childcare, that's fine, and vice versa, because then it's just too much back and forth on a high conflict case. If it wasn't high conflict, nobody would care. But here they do. So that's one example. And then there are other examples of 8 hours I've seen where it's like a full day on a Saturday or Sunday. But the most common and the biggest resolution that we see is an overnight. So if you can't be available for your child or your children overnight, then the other parent should have that right of first refusal. I have seen many agreements with 48 hours, 2 nights, but that means an entire weekend. That could be almost a whole weekend. So is it fair that your child or children are with an aunt, uncle, grandparent, significant other, anybody else other than you for all day Saturday night, Sunday, or like Friday to maybe Sunday, like a weekend? So that is very rare, but it's usually the 24 hours is usually the right of first refusal.
So what do you do, and does it change at all if you know your child is, let's say, spending a huge chunk of their time with the nanny at the other house, so they're actually not with the parent? Do you still hold that rule that parent A does what they want on their time, or is there something else that comes into play?
Well, it depends on what the stipulation of settlement says. And if that's an issue, we would address it in a stipulation of settlement. And I will say the resolution is sometimes that the parent must be there for the majority of the time. That is what I have written in stipulations of settlement when that was an issue. But what really happens, just a little nuance to that, it's not always the nanny that is the issue. It's the new spouse or the significant other that somebody's been living with. That becomes the issue. Why is my child or our children with your fiance all day, all night when I am available? And the person that the custodial parent for that time usually says, because we're a couple, we're a family, we're a unit together. And if I'm not there, just like we were married, would you have that complaint? And that's the nuance, is who the child or children are with if the actual parent can't be there, but the child's comfortable or children are comfortable with that third party.
I think that that's so important. And I've had a number of cases where my client was still single, but their ex was now engaged or even getting married. And it's such a hard, it's a whole nother grieving that one goes through. And I want to stay on this for a minute, because when we have big emotions, we also have a narrowing of perspective. Of course, my children should be able to be with me. Of course, she shouldn't be raising them all of that time. And so I know for all of my attorneys that I work with, like, you guys have this understanding of years of, if we were before a judge, they would be looking at it this way. Can we bring that part of the conversation in so that those who are listening and maybe even feeling really triggered right now about what is and isn't possible can hear what you have to say?
So I am one of those lawyers who uses that expression quite a bit. And I have been told by more than one client, but we're not before a judge. And I respect that as well. So I always say that in criminal law, there are elements for the prosecution to meet. In family and matrimonial law, there's factors a court can consider. That's why there's fighting in matrimonial and family law, because nothing is set
Black
in
and
stone.
white.
And every X amount of years, something else evolves as the main topic for whether somebody's either alienating or what's going on. Years ago, it was one thing, and then it became foster a relationship. The custodial parent must do that. Then it became something else. So there are hot topics. It depends on the judge. And I really do believe that when you are in court, you're not alone. You are there with a judge who is going to make decisions about your life, your family, who may or may not know enough information, depending on what is disclosed. And you may have a lawyer for your child or your children who is going to either state their position or substitute judgment in certain situations, which is very daunting, because here's a stranger who's saying, this is what I think is in the best interest, when that is allowed, which is extraordinarily stressful for some people. So there's no definite answer, but what there is, I would say, are guidelines, like broad strokes. I think a judge is loath to say, yes, every day for 2 hours. I know you're available. You should, on the other parent's time, you should be the one. I don't think that's going to happen. I do think a 24-hour or overnight. And we know these things from decisions that we read and from cases that we have where we're like, you know what, that judge thought that was too confining, 2 hours after school. But 24 hours, that's become standard. 48, maybe not so much. So you have to sort of know who you're dealing with. And you also have to understand what the case law says when you can find cases that resolve those issues, or decisions that the judges have made in your trials that are not published, but that you have read. And even interim decisions, when you're in court and you say, my client would like an overnight, and the judge goes, okay, you know what, let's start with 1, and then we'll go to 2. And then there are some judges who say, I see no reason why that shouldn't have happened a year and a half ago. You're going to now get Friday to Monday. And that has happened. One of my cases, first day in court, 50-50, infant. Different judge, might have been different.
Right.
But
I
that
think
judge said,
it's,
no reason not to.
and I think it's so important. So folks, Randy's a New York City attorney. So whatever, half a dozen judges and that have changed over the decade she's been doing this. But now we're talking about jurisdictions across the country, and for some of you across the world. And so judges are human beings. And I like the way you put it. There are some broad strokes. And so I would really encourage you, when you get to this point and you're talking to your attorney, to tune into what they do have to say about, if we were in court, this is kind of what the lane that the judge might swim in. And I think that that's helpful. And it makes so much sense. And I just want to validate again, it's like, this is the tender part. I know for me, it was like, my kids were so young, they were barely in grade school. And especially if you've got a high conflict spouse, there's so much concern and there's so much desire that I just, especially if they're the stay-at-home mom or parent, I want to have the kids. Why should they be with a stranger or with a fiance? Can you just, before we're going to take a break in a minute, but I just want, you just brought it up. So let's talk about the role in creating this parenting plan that a custody evaluation and an attorney, guardian ad litem, an attorney for the children, would play in creating this, if at all.
So I will start with the forensic, because that's easy. If you're litigating a case, sometimes a court says, I'm going to appoint a social worker. Usually it's a psychologist, a psychiatrist, who evaluates the family. And that person speaks to the child or children, or at least meets with them, meets with each parent, speaks to collaterals. And who's that? The teacher, it could be a grandparent, it could be a friend, it could be school personnel, pediatrician, therapist, and writes a report. And the report has paragraphs and pages on all the interviews and everything that forensic evaluator looked at. And sometimes they're asked to give a recommendation, and sometimes they're not, because in New York, only a judge can actually make that determination. But you see all the strengths and weaknesses, and it is a mirror to who you are as a parent. It's sometimes wonderful for a parent and it's validating, and other times it is very hard to read and is hurtful, not intentionally, but because you are seen as a particular type of parent, either you're a gatekeeper or, anything, or narcissistic. And sometimes it settles cases because it's so clear cut. But it's very expensive, and you're putting your children through this. The third party collaterals know you're going through this. And I think, as much as I really do love reading these reports because they're very interesting, I think it should be avoided as much as possible, because I think that people see themselves differently, which could be beneficial, but sometimes it really could just add a lot more stress to the case. Now let's talk about guardian ad litems and attorneys for children. In New York, attorneys for children represent the child or the children and advocate exactly what they want, whether that lawyer thinks it's in their best interest or not. It's very difficult sometimes to say, I want to be with so and so, the majority of the time, when you as a lawyer think, oh my gosh, that is not in this child's best interest. But we have to zealously represent the child's position. However, there are times when we could substitute judgment and say, this is what my client wants, but I'm advocating best interests. And it's very limited when you can do that. You can do that if a child it's almost up
Is it
to
an
the level.
age thing? Is it an age?
It's not really, because I've been in a case where an AFC, an attorney for a child, had a 13-year-old and substituted judgment. It has to do with whether there's a substantial risk of harm to the child, which is in New York like a neglect or abuse proceeding. So if the child wants to be with the parent who happens to have hypodermic needles around the house because that parent has a problem, what would the lawyer say? This is what my client wants. However, I'm substituting judgment, and I don't believe it's in the child's best interest to be in that home, blah, blah, blah. So sometimes, and this is where it gets creative for some people, sometimes a child is so alienated that there is case law in New York that it could rise to the level of substantial harm, because that child or children are so alienated that they no longer want to see the parent. They don't want anything that parent touches. They start calling the parent by a first name. It's so bad that the lawyer will say, even a 12-year-old, this is my client's wishes, but I'm substituting judgment. And also you can substitute judgment if you have a child who is too young to speak, too young to understand. Like I had a case where I'm a guardian ad litem because the child's 2 years old. The child can't tell me, whose home is more comfortable or is better. Or a special needs child. I've represented an autistic child who couldn't speak. So that had to be an area where I was a guardian ad litem, which is almost the same as substituting judgment. But that's very daunting for parents to hear a stranger get up and say, this is what I believe is in a child's best interest.
My divorce is so many years ago, but we had both. We had the psychological forensics, and we had an attorney for the children. And the forensics ended up virtually having no impact and was expensive back then, and now is so very expensive. And I think that when it comes to the forensics, we're dealing with judges who are schooled legally, and there's so much psychological. And so I've spoken to a number of mental health experts on the Journey Beyond Divorce podcast, where they're like, it's so expensive and its value is really, really low. Like, just because the family court system is broken, just because the emotional intelligence or a brand new judge or whatever the case may be. Whereas I feel like the attorney for the child, right, when I want this and dad wants that, the attorney for the child really can, number one, if we're truly going to be child-centric, I feel like there's a comfort for the child to know my voice can be heard. Mom and dad can't hear me because they're fighting with each other, or mom and mom, or whatever the case may be, are fighting with each other. But if I have this person who hears me and represents me, it gives them some agency in the process.
That's without a doubt. And not everything gets disclosed. There are children who say, I always ask whether I have permission to disclose. And I have been told by children, you can disclose all of this, but not this. Or it's rare, but I don't want you to, you could basically, they don't use the word advocate, but you can say what you want, knowing what I want, but don't say you heard this from me. So I would say I don't have permission to disclose the details, but I'm authorized to advocate XYZ. I often find, and this may seem a little odd, but when a child feels that way, there are reasons. I'm not a psychologist, I'm not trained as one, but sometimes as an attorney, you're happy that the child is confiding in you because you say, okay, they don't want their parent to know, but it's important enough and there's a trust here. And then in time, as you counsel and work with the child, that may be something that gets disclosed, but there's a trust. And also, we are allowed to speak with the child's therapist at times. But the older the child is, I've spoken to children about, is it okay if I reach out to your therapist? And your parents gave me permission. They signed the HIPAA compliant authorizations, but I like the child to know what I'm doing. And sometimes they are so happy because they can talk to their therapist.
Yes.
And the therapist will tell the lawyer, and they may not have to repeat what was very difficult the first time.
Yeah.
So there's a trust there. And I always hope that the parents understand that as much as this is a third party in the life of the family, there could be something good that comes out of this if there's just honesty and, again, a resolution on how to deal with it.
Yeah, beautiful. Beautiful. We're going to stop for a quick commercial break. And when we come back, I would love to talk about the decision-making and that third party, the parent coordinator, and how that plays into the decision-making. Divorce feels like an overwhelming perfect storm as you navigate pain, fear, and confusion while struggling with unfamiliar legal procedures and the pressure to make complex decisions that will impact the rest of your life. Our free Rapid Relief Call provides the clarity and confidence you're yearning for. Visit rapidreliefcall.com for support and guidance today. Of course, your friends and loved ones care deeply about you. But if you're honest, while they mean well, when it comes to your divorce, they just don't get it. And sometimes you leave those conversations feeling even more isolated. If you're feeling lonely and craving connection, support, and practical guidance, our high conflict divorce support group is open and accepting rolling enrollments. Facilitated by Karen McMahon, you join from the comfort of your home and feel heard, seen, encouraged, and powerfully guided in the emotional and practical steps ahead. Go to jbddivorcesupport.com/HCDSG and join us today. So we've covered the schedule and the calendar and a lot of those nuances. And I think when people think about custody, they often go first to time, but decision-making, especially in high conflict cases, is so complex. And there's so many different things. And I've had so many situations where a parent, it could be religion, it could be schooling, it could be holidays. There's so many, it could be electronics, it could be the electronic scooter. Where do you begin with clients on the decision-making part?
So I start with what a lot of people may not want to hear, which is judges rarely give sole decision making. And that's
let's put that right out right in the beginning.
It's not, I get people when they search the internet, I want full custody. Well, what does that mean? I always ask, because I could be interpreting it wrong. So I always ask, what does that mean? But so I start with that. And usually, unless it's consented to, you would have to have a trial and you'd have to have a very compelling argument for why you don't even have to consult with the other parent. So I start with that. I go to sometimes there's sole decision making, but you still have to notice or consult. Then I go to what final decision making is, which is you have to consult with each other. And we'll talk about what consultation is, and then some parent has a final decision. So yes, I want our child to go for this surgical procedure. Please give me your point of view, but ultimately I'm the one who makes a final decision. It's a nuance to really having sole decision making, but you have to go through a process first. And then there's joint decision making, joint legal custody. So most cases people say that's what I want is, okay, well, what happens if you can't make a decision? So again, we go through whether or not you need a very detailed email that says major decision, braces or orthodontics, or can you just email each other what kind of family this is, what kind of dynamic. And then you talk about how you've made decisions in the past and what the problems are. Perfect example, private school versus public school. There's a cost involved. There's an issue there. Medical, oh, we've always been able to make medical decisions together. Really? Okay, great. What happened with vaccinations during COVID? That we didn't agree. We were in court. Okay. That was something that a lot of people learned more about their spouse during that period than I think almost anything else, because they always agreed on surgeries. And then there was something controversial. So those are the things that we talk about how to resolve. So I will give examples of people who resolve things in what I think are pretty good ways. It's very rare that you just see an agreement that says they have joint legal custody, because that's just an agreement to agree. What happens if they can't decide?
Yeah.
So when I see people who want that and they don't want anything else, their only option is to say, and then they'll seek judicial intervention. Let's try to avoid that. So then there's going to a professional. So sometimes if you want to go to the professionals who don't cost money, you say for medical decisions, the pediatrician will make a recommendation. So now what do you do with that recommendation? You either say, and the parents will continue to try to work at it and then have another resolution if they don't. Or sometimes we say the parent that agrees with the pediatrician will make the decision. Because under New York law, a third party can't make the decision unless
I was just going to ask you why you were wording it that way, because and that's so good for me to know, because I never word it that way. I'm always like, well, what if you just always have the professional will be the tiebreaker, which is kind of what you're saying, but you're saying it in that legal nuanced way that you must.
It's in an allowable way. Yes, right. It is in and there has been my very first matrimonial trial. That was an issue that went to the appellate division, and the appellate division knocked it down because the court's decision said the third party will make the decision. Right. And the judge had to change her decision because it had that nuance. So it actually is in case law. And that is how, for lack of a better phrase, we get around it, is to say the parent that is aligned with that professional. So who is it? A guidance counselor, a therapist? And sometimes we list the actual professionals. The problem becomes if somebody says for school, guidance counselor, principal, and teacher. Well, then how do you decide? You're going to fight. One said this, one said that. So you really have to be specific. Sometimes they say if you can't agree after that recommendation, then you go to somebody like a parent coordinator. And a parent coordinator, there's a cost involved, unlike maybe just talking to a pediatrician or the educator. And also, this is a fight a lot of times, is the extracurriculars on the other's time, league sports on weekends. Who is that third party? Sometimes you could only go to a mediator or a parent coordinator, because what teacher may get involved in something like this? Okay, yes, it's good for the child, but really,
before you go on, we've got episodes they're in the show notes on parent coordinator, but please just describe the role of a parent coordinator and then how they come into it.
A parent coordinator actually is very, I think, focused on the child and the children. And unlike mediation, where they're really making the decisions, you're helping them make a decision, or you actually have the power to do it.
Oh, really? In New York, you have the power to do it?
If that's what the retainer says. And some retainers actually don't say that, and some do say that. Some stipulations of settlement say that they will they will be the one to issue the recommendation. And again, it would be worded that the parent would have to consent to the parent that's aligned with that recommendation.
Would be actually making the decision.
Right. Gotcha. So it's a little bit more intense, I think, but that person also gets to, if they want, speak with the doctor, speak with the teacher, speak with as many people as that person wants. Sometimes asked to speak to read the forensic report, which you'd have to get from the court if the court allowed it. And sometimes really does all of those steps that somebody would do almost if they're prepping for trial to some extent to get all the information. So it is I think it's a great service, but I also think that, and I've seen it, people are freer to speak in a parent coordinating situation than in court because they know you're really listening in detail to everything they want. And there's no time limit. Like in court, you're there for a certain period of time. So I do think that it works because people let go of some of their issues as they're really talking about it and having somebody understand. But again, a third party is not going to make the decision, but it does, you can have that. I've seen stipulations that actually have had that. Again, it would be phrased in a way that would be allowed. And again, you're relying on a third party. But ultimately, a lot of it seems very much like mediation but instead of just talking about what the parties are thinking, you're actually also involved in asking certain questions and getting certain things done and getting to a resolution that you believe, hopefully, is best.
So you act as a parent coordinator at times. So if a couple has divorced, it's in their settlement agreement, they've chosen you, I believe you can actually write a particular person in the agreement. Is that
Yes,
true?
I have seen that, and I have been in agreements as well.
Okay, so, and I don't want to go too far down this rabbit hole here, but do you meet with both of them together? Do you first meet with them separately? And the other thing, and again, we could go into a whole session on this, which I don't want to. I know that some parent coordinators have a legal background and some parent coordinators have more of a psychological background. Is that true in New York as well? Yeah. And so actually, can you talk more about how does one choose? Let's go there. Let's talk more about how does one choose if you're at this point and you're like, okay, we're gonna have the expert and then we're gonna have the parent coordinator. Give us some guidance to how to choose a parent coordinator.
That is a great question. Usually the recommendation comes from lawyers or people who've used a
So
parent
both of
coordinator.
our attorneys would come up with a list of where they might agree or where there was crossover, something like that.
Yes, yes. That happens more often than not. I don't think that people should put in a stipulation and then they'll go to a parent coordinator. Okay, well, what's the process if you don't agree on one? It's exactly what you're saying. So sometimes people interview a parent coordinator and you hope you never see them again, that their agreement is great, but you still have that session with them. And other times you do an organization. If the lawyers are in court and there's a blank and nobody can figure anybody out at that moment and they're ready to sign and you want to strike while the iron is hot, as they say, some people say you will go to X organization who will assign somebody to you. And sometimes there's a process that this one will bring 3 names, this one will bring 3 names, you will interview X, and if you can't, then you do what. Sometimes there is a process. It's rare because if you're at that level, you've done almost everything else and you don't want to write 5 pages on how to select somebody. But a lot of times it's the lawyers who trust that parent coordinator who has done a good job, or that they're not biased from one gender or another, and they're not anything other than going to be fair and do the right thing. And that's often how you get selected.
Beautiful. Let's move on to, so we have medical, we have educational, we have religious, and there can obviously be a lot of complexities in all of that. But, and then there are the nuances, which there are so many of. And I know you and I were talking about extracurricular. I was not thinking about my children driving, buying cars, getting insured, who would do any of that because they were barely in like first and second grade when I was negotiating. And I'm always saying to my clients, you cannot negotiate based on where your children are. You have to negotiate based on the entire lifetime, which is so hard when you're a new parent because you don't even know what you don't know.
Well, I always say our crystal ball sometimes has to be bigger than yours, but sometimes I need my client's crystal ball because they know who they're dealing with.
Yeah.
Or they know that someone, so I'll give you examples if I may,
Yes, please.
nuances that have come up, and that this is why stipulations of settlement sometimes get bigger and bigger and bigger over the years, because now you realize there are other things to consider. So a nuance, we worked out everything, and then it became where you're going to travel with the children. Okay, we'll talk about Hague and all of that, places that may or may not have some significance, but what happens if somebody's home, they want to go visit a relative, and the relative lives in a state where guns are allowed out, open, public, everything, and one parent doesn't want that? I would have never put that in an agreement absent that was a particular family where they had decided the children would never actually stay over that particular home. But now that there's a divorce, all of a sudden the parent says, we're spending a week there. Okay, so now it's an issue. Showing up at an activity. Yes, people could show up for league sports or when there's a recital, but what about a regular game on the other parent's time? What about just a rehearsal or a gymnastics lesson? That's come up. Driver's ed, is that an extracurricular activity? When your kid's 7, you're not thinking of driver's ed. And with child support, who's paying for gas, registration, and maybe a car being fixed, for, let alone buying a car for a child, which is not an enumerated add-on. Okay, school lunches. There are parents who say, I am paying X amount in child support. It's to cover everything other than the delineated add-ons, medical insurance, unreimbursed medical. I'm not paying for a kid's lunch. And the child is going to school on your time too. Now, that is an issue.
I've never
Okay.
heard that one.
Yes, I couldn't have made that up. Let's just say that. Then there are things like paying for gymnastics or paying for rock climbing. But what about the gear to pay? Now we include and gear in child support, because is it fair that you could say, yes, I'll pay 50% for the lessons, but not pay for the cleats or for the tennis racket or the tutu? Okay, those became issues on the child support side. What about trips to colleges? Who's paying? You could say so and so's paying college expenses. Well, don't you want to visit the college? So who's paying for that? And how many trips? You're going to go to 10 schools, and they're all in different areas across the states. Hotels for away games. If you say, yes, I'll do this sport, it's almost like that, the cleats or the tennis racket. These two are my favorite, these next two, because if you have a family that this is an issue, you can work it out in an agreement and avoid court. So that's why they're my favorite, if they can work out. Gifts for teachers. That's not part of child support, but sometimes there are gifts that you give teachers in certain schools. Tips for camp. Same thing. Is that part of the camp expense? Or what about special birthdays, like you're going to a quinceañera or you're going to a sweet 16, your child is going and it's on your time? Do you buy the gift for the kid's friend? Or is that not part of child support? Or is it, well, this is something our child is doing, we need to do that. Bar and bat mitzvahs, the same thing. How about having one of those events? Are we having your family and my family? Are we having two? Are we having only one? How are we going to handle? And if so, who's paying for it? Who is going to be invited? I don't usually put those things in agreements, but I have had clients who've wanted that in an agreement because the child was going to hit 16 or 13 or whatever it was, and it became an issue. But these are all things that really matter. And technology is a big one. It's not just what age should our child have a phone. It is how often is it used? Usually there's a find my friends. So does it stay in a person's home, or does the other parent always know where the child is when they're with one of the parents? So it becomes very detailed, but these are nuances that occur in cases. Haircuts. Who's paying for a haircut? It's not a enumerated expense. It's part of child support. What about, yes, uniforms for a private school? That we can say is part of the private school, the finances of a private school. But what about clothing? kids going to events. What about clothing? Bringing clothing when your kids are young, back and forth.
Oh my God.
I'm laughing at your reaction because that is the exact reaction. It is such a big deal
It's a
that,
huge deal.
and people will spend money on their lawyers arguing about a pair of rain boots.
Yeah.
That when you go online and you see how much the rain boots are, you could have just bought a second pair, but that's not the point. The point is that it's not coming back to the person who purchased it, and when clothes come back dirty.
And it sounds so ludicrous, and yet I can't tell you how many clients where they're like, how many things do I buy new and nothing ever comes back? And it's like out the door, out there. And so it sounds so petty. And then you'll have legal people going, well, come on, we've got bigger things to deal with. But it's actually, my kid's 9. I can't do this for the next 9 years, right? And so it actually is more of an issue for those where it's an issue. Yeah, I had a few of those. I want to ask about a few more things. One is what you alluded to before. So passports, birth certificates, like what occurs around the negotiation of who's holding on to vital documentation? And because I'm bringing up passports, international travel, because I know that's an issue for a lot of people.
It's always in our agreements, domestic and international travel. Okay. Passports, you have one usually from the country that you are in, and there is sometimes a battle as to who holds it. So let's say you have a 50-50 parenting time schedule. Okay, so there's not one that is more of the custodial parent. Sometimes if they can't agree, we say a safety deposit box, because then you always know when somebody signs it. Sometimes we say in odd years, one parent, even years, the other parent. And then we have and usually I'm sure that they forget in time because if they get along, but there's a protocol as to when the other parent has to give the passport. And what I do in my agreements is I don't do it 2 days before or 3 days before, because if somebody doesn't do it, the other person's trip is ruined. So I do it with enough time in case if somebody has to go to court and say, I'm not getting the passport. Nobody wants that, but nobody also wants to have an emergency motion done in 48 hours because your stipulations that they have to give it to you 2 days in advance. So I like to give a buffer and when the other parent returns it. So that is always in agreements. Also, the use of foreign passports, that's an issue at times. And usually a national from a different country wants their child to get the benefit while the other parent may be nervous of a passport that they can't have any say in. So that's an issue. And domestic and international travel, a lot of people put in Hague provisions that New York is the home state, will have continuing an exclusive jurisdiction and all the framework for if there was a Hague issue, getting the child or children back. We usually put in our agreements that either party or both parties can travel with the child or children to Hague signatory countries without consent. Some people add if there's State Department warnings, they add that. But we always have telephone contact. This is a rare thing, but we do this at times. When you have joint legal custody in some countries, that can mean that can have a significance different than maybe the way in New York we read it. There are times if somebody is going to travel internationally that we write in an agreement while the traveling parent is overseas with the child or children. The non-traveling parent has sole legal custody for purposes of the Hague Convention only, which means that they will have this power to get the child or children back without saying, oh, that parent also has the same rights. So it's very limited to, and that is if a parent says, I will agree to the international travel, but I am nervous that I don't have any more rights than somebody, and maybe less because that person's going to a country where they have family. So that's rare. But again, the whole idea is to try to think of problems. You can't think of everything, but you try to think of certain concerns that each client has, or the other side also, and try to say, how do we eliminate that as a concern? When you do that once, that person is more likely to say, okay, I will bend on something else. But you need to know why somebody is so concerned about certain issues. And a lot of times they have valid points. And a lot of times you have to sort of say, we understand, but I'm not quite sure the court would see it this way. Let's see if we can find something that we can do that's not 100%, but will give you some peace of mind.
Beautiful. So as I'm listening to you and I'm trying to summarize key categories, and so help me with this. When we're doing a parallel parenting plan, writing in nuance that includes timing of when and how, resolution if it doesn't go the way it's supposed to, and
If somebody is late, what happens?
right,
Is there
like
a grace period? And what happens if they miss the grace period?
perfect. And then professionals, if you're going to have professionals that are written into it. I'd love the last piece of the do you want to add anything? Is there any, so I'm thinking timing, resolution, professionals in all of the nuance.
Yes, and things that you have to also predict, such as real life situations, introduction to a significant other,
Yes.
and sleeping arrangements. If that happens, who can pick a child up from school? Is it only you and the other parent, or is it a significant other too? Is it a parent of one of the parents? Little things like that are big things to many, many people. Who can sit in on a conversation with a physician? Could the new wife or husband? Could the new spouse? Are they on the emails? So yes, we nuances can go very, very detailed and deep.
And I'm just going to say, I'm sitting here smiling for those of you who are just listening to the audio. I have such a long list, and you just added so many things that I've never thought of for my 15 years. And I had my own list. And so, folks, I'll tell you, I spent 3.5 years getting divorced, and there was really nothing to fight over. We ended up with 50-50 custody. There was no money. And still, when we started with the schedule, there was so much nuance. And I'm like, how is it that we spent 3.5 years and we didn't think about A, B, C, D, and E? And so no matter how thorough you are, once you start living it, there's going to be something that comes up. But Randi just did such a gorgeous job of giving so many different possible details. And you can't, like, this is something I do with clients. We just have multiple conversations and what if and how would this work? And you can't talk about this enough to try, especially in those high conflict cases, to try to have as much as possible. And yet, and this is where I want to end the conversation, there's a pro and a con. There's a yin and a yang to having that much detail in the parenting agreement. Like you might be negotiating for 10 years. So can we wrap this up with a little bit of your wisdom and guidance for how to balance concerns and getting this thing done and over with?
Thank you. And that's the key, because yes, you can negotiate for a very long time and things change during that time. So I think that when you take each person as an individual and to understand what the concerns are, and then to counsel that client, because some concerns, everything's going to be valid to that person. You have to understand that. But some are based on things that it's not necessarily for this family. It's because a friend had it, or because they read it somewhere, or because there is a fear that this could happen, like the significant other situation, okay? Or how many people are going to come in and out of the person's apartment. So I think you have to first start with what are the concerns, then that realistic approach, what a judge could do, what a judge may do, or having to have forensics or an attorney. And that will turn a lot of people off at times. And then to say that what really needs to be addressed, what really you cannot live without, and please tell me the reason. And then we draft an agreement. And obviously, there's going to be some pushback and some people let go of things. But I think that everybody has to understand that things change in time, and that an agreement is a contract, it's binding, and you can't just ignore it, because then it could be thrown out. But if you guys can agree, then you have a guide. So you either try to agree or you don't. And I'll give an example of like Christmas Eve and Christmas Day. There are people who want to split like Christmas Day. Somebody gets the first half of the holiday, somebody gets the second. And there are people who say, nope, the 26th is going to be the breaking point, right? But in time, people may say, you know what? I'm now with a new family. Everybody spends Christmas sometime together on the day. Can we modify this? And either A, you modify it and you agree, or you do it formally with an amendment with the same formalities as this agreement. But the hope is that you never have to rely on every little single point. But if you can't agree, that is it. So be careful what you put in an agreement because you are bound by it.
And I think you said that to me when we first spoke. It's like the downside of something that is very boundaried and ironclad and rigid is it might bite you in the ass.
Mhm.
And so I just think that's a really good point. And for me, Randy, when I'm talking my clients through their parenting plan, a big question I ask so often is how important is it? Because
That's
you're
it.
used to being under the same roof with your kids 24/7. And so, for me, I had to give up my son going to bed at a certain time and not gaming well into the night. And it's like, well, that's really important because then he could get bad grades. And I'm still trying to control my child all of the time. And because I don't think the other parent is going to do what I think should be done. And I think that that's one of the hardest things and how devastating is it going to be to the kid and how important is it? And are there other ways other than writing the details into the parenting plan? And I often talk to parents about if your child is staying up too late, maybe you stop with the negotiation and you start talking directly to the child because grades are important to them and their grades start going down because they're like gaming when they should be sleeping. Maybe there are other ways around it. And so I think that as we wrap this up, there's so much nuance. There's so many different possibilities of how to build your parallel parenting settlement agreement and talking it through, having numerous sounding boards, and really challenging yourself. How important is it? And I would even say, once you have your entire list together, put it in priority order. Because if you have to give some things up, you can't say, I'm not giving anything up. You'll be negotiating for a lifetime. And so picking and choosing those most important pieces.
I think that's great advice. And just remember, which I know you do, but parallel parenting is about allowing a person, a parent, to have their own parenting style during that time with the child or the children, as opposed to let us co-parent and know what's going on in the other home. So that's the nuance. That's the difference between that and a regular, I would say a regular stipulation of settlement. But in order to not, as you say, you could get like bite you as well, because you may not like what's going on in the other person's home. And all
Yeah,
of a sudden, now you don't have that control. That's the separation.
I'm going to say it in a different way. What I just heard you say is you can't have it both ways.
That is
You
a better way of saying it.
can't be a co-parent because you want to have control in their house, but have a parallel parenting because they're so controlling. You don't want them to be burdening you with their way. And so this is where we have to surrender to a certain degree. We really have to surrender and trust. And in my humble opinion, this is where we build relationship with our children and help them grow their decision making and their emotional intelligence throughout the years as we support them in making good decisions, even if the other parent is encouraging them to do whatever they want.
That's perfect.
I believe you have a gift for our audience.
I am always happy to help any way I can, especially people who are going through a divorce or a separation, or even think that they may go through one, because sometimes, as they say, a stitch in time saves nine. Sometimes knowing your rights, your obligations. I could only speak about New York law. I'm only a New York lawyer where I practice. I'm admitted in other places, but I don't practice there. But I am happy to give anybody a free hour-long consultation on with involving their particular situation. So it's very personalized to that person. But again, it's only based on New York law, and I'm happy to do that. All they have to do is mention that they listened to your podcast.
Beautiful. So that's in the show notes, folks. And why don't you just say what your website is, and we'll have that in the show notes too.
And thank you. It's very simple. It's my name. It's randikarmel.com. So it's RandiKarmel.com. And my email address is randy@randikarmel.com. As simple as I could have done it.
Randi is one of my go-to New York City attorneys when somebody's looking for an attorney. If you're not on video, I call her a firecracker. She's got gorgeous red hair, and she is as deeply heart-centered as she is capable of being such a firm advocate in court. Randi, one of the things I wanted to ask you was, do you have, given everything we just talked about, do you have some kind of an outline or a checklist or any kind of guide when it comes to building a parallel parenting plan that we could give out to people who are entering that?
So that's actually a great question. I don't have like a form. That's just not how I handle things. And that doesn't mean that it's the right or the wrong way. We do have our stipulations of settlement that we have, I think, evolved throughout the years, and they're longer and longer when we deal with things like this. When they're very detailed, sometimes I'm stunned at how long that they actually are, but we hope that it avoids court. So I don't actually have an outline. We use some of our documents depending on how detailed. Like I will tell my associate, oh, can I have X's or Y's, which was usually the first time we had to deal with certain issues, and we go from there. But I think that there are outlines. I did some research before this podcast. If you just go to co-parenting and parallel parenting, there happens to be something by a Dr. Garin, Garin, middle initial D, Vick, Vick. It talks about co-parenting tools, tips, and tactics. And it does give not quite as it doesn't give the examples that I have given through my practice and through what I see, but they really go through a lot of what somebody can expect and look at for a co-parenting agreement.
Beautiful. So we'll have that in the show notes as well then. Randi, thank you so much. I just love having you on. You have such a depth of experience. You just bring so much nuance to every conversation. I so appreciate all that you do.
Well, thank you. And I certainly appreciate what you do for the community and helping people go through a divorce, not just dealing with their spouse, but also, as I have always told you, sometimes dealing with their own attorney, because it's a stressful situation. And as I've always said, I've called you Elmer in the past. Sometimes I believe, if not all the time, that you are the glue that holds everything together. So I am thrilled to be working with you on this. And thank you so much.
Well, thank you for those kind words. And folks, we'll be back again real soon. You have a great day.